My name is Lynn Rhinehart. I'm the General Counsel of the AFL-CIO. We're a labor federation representing about 11 million workers across the United States, and we are in strong support of the Protecting America's Workers Act and the provisions in it to strengthen the penalties and strengthen the whistleblower protections in the law. We really appreciate your holding this hearing today on Workers' Memorial Day, a day when we honor and pay tribute to workers who were killed on the job, and I want to acknowledge the family members who are here on the panel and here in the room and express our sympathies for their loss. We're all here for the same reason, which is that we believe strongly that those fatalities should not have occurred in vain, and that we need to redouble our efforts to take measures, strengthen the law, do what we need to do to make sure that further fatalities don't happen in America's workplaces. And frankly, we have a lot of work to do. Still today, 5,000 workers, more than 5,000 workers, die on the job each year. That's 14 workers each and every day who are killed from workplace hazards, and millions more are injured. 5,000 workers a year is the population of many small towns across America. And it's that number of workers killed on the job each and every year from workplace hazards. It's just an unacceptable level of tragedy in America's workplaces that we have much work to do to address. I think everybody on the panel would agree that in order to address workplace hazards and to try to get preventive actions in place before injuries, illnesses, and fatalities occur, that you need the full and active involvement of workers. Workers are the eyes and ears in the workplace. It's their jobs. They see the hazards. They know the hazards. They know what solutions might be put in place to address those hazards. And so employers who are being proactive about health and safety in their workplaces want and need the full and active involvement of their workers in identifying and raising hazards. And especially given the fact that OSHA can't be everywhere at all times. In fact, it would take them 137 years to be in each workplace just once. All the more reason why we need the active and full involvement of workers in identifying hazards and protecting their health and safety on the job. In order to have that active involvement, workers need to feel secure that if they raise a hazard, if they bring a concern forward, if they file a complaint with OSHA, that their jobs are going to be secure. They're not going to be fired or demoted or transferred or suffer other retaliation for speaking out. The system really depends on that. And unfortunately, we don't have that situation today. As Mr. Jorgensen's story so painfully shows, workers today do not have a right to speak out about job hazards without retaliation and have a remedy behind them for speaking out and pursuing their rights. It's even more important in today's bad economy that the law be strengthened. The fear of retaliation, the fear of losing one's job is even more intense when you're looking at an almost 10% unemployment situation, and that just exacerbates workers' fear of speaking out. Workers who are covered by a union contract are in a better position because they have their union in that contract backing them up if they suffer retaliation for reporting job hazards. But unfortunately, that's a protection that's only afforded at this moment to a minority of workers in America's workplaces. So most workers are left with the protections of the Occupational Safety and Health Act, and these protections by any measure are exceedingly weak, and they are the weakest of any of the 17 laws that OSHA, whistleblower laws that OSHA itself enforces. How ironic that the weakest law enforced by OSHA is the OSHA Act. I attached a chart to my testimony that laid out some of the ways that the OSHA Act's anti-retaliation whistleblower protections fall short of the standard laid out in so many other laws, including Sarbanes-Oxley, including the Surface Transportation Act, including the recent health care reform that was adopted. By any meaningful measure, the OSHA Act's whistleblower protections fall short of the mark. The statute of limitations is exceedingly short, only 30 days. There's no right under the OSHA Act for workers to get their jobs back for preliminary reinstatement while their cases are pending. And they have no right to get a hearing before an administrative law judge or a court. They're completely dependent on the Secretary of Labor bringing their cases forward, and as we've heard, that rarely happens. And the burdens on the Department of Labor are significant as well. They can't pursue an administrative process themselves. They need to go to federal district court to pursue these whistleblower cases in court. So The law is extremely weak. There's a saying in the law that rights without remedies are really no rights at all. And frankly, that's what we're talking about here with the whistleblower protections in the Occupational Safety and Health Act. The provisions are so weak as to really be meaningless. So we support the provisions in the Protecting America's Workers Act. We think that they would make a real positive difference in protecting workers' ability to raise safety and health hazards on the job. It would update the law, bring it up to par with other anti-retaliation protections and other laws, including laws that have been passed over the past 5 years with bipartisan support and signed into law by both Republican and Democratic presidents. We think that these measures would give workers more meaningful rights to participate in safety and health on the job and bring about preventive efforts before injuries, illnesses, and fatalities occur. I'd like to make just two other brief comments in the time that I have. One is that while we fully support the provision in the Protecting America's Workers Act that would give workers a right to pursue their own case before an ALJ or a federal court if the secretary did not pursue their case or if the case was proceeding too slowly, we don't view that right as a substitute for the Secretary of Labor still having her own robust anti-retaliation whistleblower program. We think you need both. You need the agency program and you need the private right of action. The other comment I would make is that it really seems to me that employers ought to support the provisions, the anti-retaliation provisions in this legislation, because employers who want their workers to feel secure speaking out about job hazards should support there being a law to back workers up when they do step forward and exercise those rights. These are modest measures. They're not novel. They're not radical. They would simply bring the OSHA Act into the mainstream and make it more uniform with other anti-retaliation whistleblower laws that have been passed by Congress over the years. So we think it's necessary. We think it's overdue. And we urge their prompt adoption. Thanks very much.